that the monitor staying on the car really doesn't serve any other purpose other than punitive. And I know technically, I guess it could be considered a punitive measure. I noticed there was some mention either by the probation department or the prosecutor that she had a 2003 DWI and that the breath test was 0.14, which if she hadn't had the 2003 DWI, she wouldn't have had the interlock on her car anyway, unless the court just made it a condition of probation on her own or on your own volition. So that something that happened 16 years ago, you know, I think, you know, she's learned her lesson by all the stipulations that she's went through. And, you know, with no bumps in the road, we just ask that court consider all that and enter an order removing the interlock device. I mean, she's still on probation, so it's not like we're just letting her go and she can go on about her life. I mean, if there's any other bumps in the road, then probation can still catch it. I don't anticipate that being an issue anyway, but anyway, that's my final thoughts.
What does the state have to say about this request?
Your Honor, the state would oppose the request simply because this is the second DWI for this defendant. I would call probation officer Sean Jackson.
Yes.
Okay, well, hold on a second. We hadn't even gone on the record yet. I think counsel just kind of started going ahead with arguments and we hadn't started this record. So if you want to call somebody to testify, we're going to go on the record and cause number M1913686, the state of Texas versus Felicia Hudson. This is a hearing on the defense's motion for an interlock removal, as Ms. Hudson is on probation currently for DWI second. The state of Texas is represented by Assistant District Attorney Ms. Zui Kotare. The defendant is present here with her attorney of record, Mr. Gary Smart. Also, the court's probation officer and the court's court reporter are here, and we are all appearing over Zoom. Let me just ask you briefly, Ms. Hudson, do you agree that this hearing be conducted over Zoom? You're muted. Can you unmute yourself, please?
So sorry. Yes, ma'am.
Okay. Mr. Smart, if you would briefly state the grounds of your motion so that we can have that on our record.
Okay. I emailed to the court, and probation has it, but her repeat offender program, completion certificate, her victim impact panel, completion certificate, her completion of the intensive outpatient program, and a receipt showing that she has paid over $1,652 in fine and court costs. Would ask the court to take that into consideration. And just by way of proffer, this should also be documented in the probation file, that she is a stay-at-home mom with a 13-year-old son. Recently got back with her husband, so her home life is more stable now than it was before when she got this DWI. And that's all we have at this point.
Okay, what says the state?
Your Honor, at this time, the state would like to call probation officer Sean Jackson.
Okay. Mr. Jackson, can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
Mr. Jackson, you heard defense attorney talk about some of the conditions that this defendant has already fulfilled. Is it true that Ms. Hudson has completed these conditions early?
I don't have any. Well, I do have proof of her DWI intervention class being completed. She may have completed the other courses as well. but I was just given this scenario about 15 minutes ago. So I haven't had time to look over my files, make sure she's completed everything else. If you give me a second, I could look in my file right now and look. We do have proof of IOP completion. We do have proof of deed of education completion. And I'm not seeing the one for victim impact panel. Oh, I'm sorry, hold on. We do have proof of, so the courses that were assigned to Ms. Hudson for conditions of probation, victim impact panel, repeat offenders, deed of education, repeat offenders, and IOP and evaluation. We do have definitive, reliable confirmation she has completed all those conditions.
And have there been any problems with probation, any probation violations up to this point?
No, she's done fairly well on the monitor.
Okay, and do you recommend the interlock being removed at this point?
No.
And why is that?
As her attorney stated, she does have a prior DWI, and we cannot minimize the significance of a prior DWI. It shows and illustrates that there was some type of chemical dependency issue. She did go to IOP and address that issue, but for safety and concerns of our community, we want to and request that we keep the monitor on until June 12th, 2021, which would be the full term of her probation sentence.
I pass the witness, Your Honor.
How's the community going to be any safer now on December the 7th than they will in June of 2021? What happens then? What's the difference between now and in June? What's going to change?
Well, I can't control what goes on outside of probation, but while she's on probation, probation department does not want to be liable for any clients on probation that are on for a DWI the second. As you watch the news, you do see cases that people are on probation for DWI offenses and they weren't properly monitored. So outside of June 12th, I can't speak to that.
Well, you said that there was a danger to the community or a potential danger to the community, and that's the reason you wanted it to stay on until June the 12th.
Right.
So if there's potential for danger to the community on December the 7th, is there not a potential for danger to the community on June 13th?
June, absolutely. But again, she's currently under supervision out of County Criminal Court number 2 in Dallas. And that's what I'm a probation officer assigned to that court. So it is my recommendation that she stays on the monitor based upon that fact that she has a prior DWI.
Well, a minute ago, you said that it was because there was a danger to the community, and now it's just because she's on probation in County Criminal Court number 2.
No. Okay, to clarify that she's a danger to community, that she has a prior DWI while in 2003. She was convicted of another DWI, so she has 2 DWIs. She's on probation at County Court number 2. While she's on probation, we can govern her having the interlock on her vehicle during that time. Outside of that time, when she fulfills her obligation and her requirement to the court, then is it possible that she is a danger to the community? Absolutely.
And you mentioned that the issue with regard to the 2003 DWI, that she addressed that with the IOP program. Did you not say that?
I did not say that. I would imagine that her issues were addressed, not just the 2003 WI, but the totality of her substance abuse and chemical abuse was addressed during her IOP session. So that's what they addressed. They addressed triggers, they addressed environmental factors, they discussed different things while in counseling.
Okay, nothing further.
Thank you.
I have nothing further for this witness, Your Honor.
Okay, do we want to have any arguments at this time?
Yeah, yes, Judge. I don't, as I said before we got on the record, which I guess I jumped right into the water before we were ready to go. But Miss Hudson is a stay-at-home mom. I mentioned she does have stability now, more stability than before. The danger to the community issue is no more of an issue today on December the 7th than it will be on June the 13th, 6.5 months from now. So if the purpose of the interlock device is to minimize the danger to the community, that it's not going to do that. And she's on probation. So if there's anything that needs to be addressed over the next 6 months, probation can still address those issues, irrespective of whether she has an interlock on her car. There's no indication of any other alcohol abuse. She's been through, as the probation officer said, she's been through IOP to address any substance abuse issues, any triggering mechanisms that would lead her to drink. I just think she's done everything that she could possibly do to warrant removal of the interlock device. And as I said earlier, if there was not a 2003 DWI, she would not have, the alcohol concentration that she currently had on this current DWI would not have been enough to trigger a mandatory interlock device. And I understand the law says if it's your second, it doesn't matter how old the first one was, that it's mandatory. But I think she's done everything she could possibly do to warrant removal of the interlock device, and that's what we're requesting.
Ms. Katari, you have a response?
Briefly, Your Honor, the state would oppose the order to remove the interlock device because this is the second DWI for this defendant, and the blood alcohol concentration in this case was a 0.141, which, while it is below a 0.15, is still quite high. And, you know, if probation had been given without the prior DWI, we could have still recommended an interlock device, even if it were not mandatory. So at this time, we believe that the responsible thing to do is to keep this defendant monitored while she is under court supervision.
So I just have a couple, easy questions. This conviction and this probation arose from a plea bargain, is that right?
Yes, Your Honor.
And somebody in the midst of that plea bargain agreed to have an interlock device installed, even though, as defense argued a minute ago, that it wasn't mandatory. Is that correct?
It is mandatory.
Pardon me?
It is mandatory because it's their second DWI.
Because of the second DWI, not because of the amount of the score.
Correct.
That was what you were arguing. Okay.
Right.
And so, are you finished with your argument, State?
Yes, Your Honor.
Okay. So the thing is here, and I think, it's most important to me that Ms. Hudson understands my points that I'm about to make. You have a DWI conviction from 17 years ago. I would say 17 years ago is when I started practicing law. Okay. You got a second DWI allegation in 2000. I'm assuming this case was in 20 or 19.
Yes, ma'am.
When was this arrest, Zooey?
It was just February of 2019, Your Honor. 2019.
Okay. So, you get a second DWI allegation with a 0.14, which is almost 0.15, honestly. And there are instances in this court where people do have to get an interlock, even though they're not at 0.15, they're at 0.14, 0.12, and they didn't have a DWI second. It's just based on the circumstances of each person's case. Okay. Sometimes there was an accident, for example. Somebody could have a 0.14 blood alcohol concentration and there was an accident. So the state is like, well, they need an interlock so we can avoid any alcohol involved driving in the future for the period of time during which the court is monitoring the individual. So there's a chance that you could have still had an interlock device imposed as a condition of your probation, even without the first DWI. It just depends on your situation. And so that being said, this court also supervises hundreds of other people on DWI probation councils. And it is not typical of this court to remove interlock devices during the probation on a DWI second. And whether it be considered or perceived as punitive or protecting the community, I believe that it does protect the community because it is the only device that we have to stop the defendant from drinking and getting, at least, incapacitate the vehicle in that moment in the event alcohol is blown into the machine. So I commend the defendant for completing all of her other conditions early, going to IOP, seemingly addressing any sort of chemical dependency issues she may have. But at the same time, if we remove the interlock device on an individual who's on probation for a DWI second conviction, I personally, which is my probation conditions, is this court's conditions that she's following. I don't think we have any way of really monitoring what I think is the most important condition of probation is the non-consumption of alcohol in this instance, when you have a second DWI. And so I'm not comfortable removing the alcohol monitoring device that is the only real deterrent, like tangible, concrete deterrent that we have to make the court feel comfortable that the community is on some level a little bit less likely to be infringed upon by another DWI by your client up until the end of this probation term. June 12th, I think, is the date you guys are referring to. So I do believe that the device does help keep the community safer while a person's being monitored. After the court loses jurisdiction over your client, it's not really an issue anymore of whether this court has any say or effect on Ms. Hudson's actions and how those actions are safe or unsafe to the community. But as long as we're monitoring her, I do feel, or the court does feel reassured on some level that she's not going to do this. And counsel, you and I know, once you get into this criminal justice system and you got a prior DWI, it's hard. Ms. Hudson, it's hard what you've had to go through. 95% of my docket is DWIs. I understand, and I know I'm very much knowledgeable about what the defendants in my court have to go through. But that's the way the laws are written. Okay. And once you gain a criminal conviction on any level in any area of the criminal justice field, unfortunately, that conviction weighs on you in the next time. And like I said, I commend you for complying and doing everything else you need to do on probation, but I need you to just stick with me and hang with these conditions and not get any alcohol blows in the machine and just get through it. And God willing, it'll be over with on June 12th. Or I'm sorry if I got the date wrong, but it's June 12th. And that will be the end of it. But this is the lot that you've been dealt because of some of the decisions that were made. Does that make sense? And I mean that in the most respectful manner.
Yes, ma'am.
And I didn't mean to upset you. I'm just being honest about everything, okay?
Yes, ma'am.
Mr. Smart, do you have anything else you want to add?
No, ma'am.
Ms. Kotari, anything you want to add?
No, Your Honor.
Okay, so the defendant's motion is denied at this time. And we're off the record.
Okay.
All right.
Thank you, Anna.
Thank you.